You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 26, How Can I Get Reduced Patent Filing Fees? My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at patentingforinventors.com, that's patentingforinventors.com, or you can call me at 424-281-0162. And while most attorneys can only practice in states where they are members of that state's bar, patent attorneys are actually allowed to practice patent law for clients in any state, so feel free to contact me regardless of where you live. In the past episode and episodes to come, I'm going through the documents you need for filing your application. When filling out some of these forms, it's going to ask you if you are a small or micro entity. Now, what does that mean? The Patent Office charges different fees for different kinds of applicants. It doesn't want to charge the inventor working out of his or her garage the same fee that it does Apple computers for filing an application. The Patent Office groups applicants into 3 categories: large entity, small entity, and micro entity. For almost all fees, the small entity fee is half of that of the large entity, and the microentity fee is almost always half of that of the small entity. For example, there's a fee for when your patent issues. For a large entity, you have to pay the Patent Office $1,000. If you're a small entity, it's $500. And if you're a microentity, it's $250. Remember, these are just fees charged by the Patent Office and have nothing to do with attorney's fees. Attorneys generally don't charge more or less based on the status of their client. They generally charge for the time and effort of the project that they're doing. So let's figure out if you might qualify. We're going to start with small entity, because if you don't qualify as a small entity, then you're a large entity. It's only once you've established that you're a small entity that we can see if you further qualify as a micro entity. So what is a small entity? Generally, if you're a nonprofit, an educational institution, or a company with fewer than 500 employees, then you're a small entity. You do want to be a little bit careful with the 500 employees rule, because it's not just the company itself, but affiliates of the company. So maybe a company is small, but it's a subsidiary of a larger company. You might have to count the number of employees of the controlling company and any affiliates. If you have investors that can control your company, and the investors are part of an investment firm that has lots of employees, you might need to count them too. Also, even if you're an individual inventor, but you're obligated to assign your invention to a large company, you have to count the number of people in that large company. If you're unsure if you qualify, you probably want to consult an attorney before making the determination if you're a small or large entity. So once you've established that you're a small entity, you can determine whether you might get even lower fees from the Patent Office as a micro entity. To qualify as a micro entity, there are 2 ways. One way is by income, and the other way is by having a relationship with a U.S. institution of higher education, so a university, regardless of your income, or if you're obligated to assign your invention to the Institute of Higher Education. Under the higher education basis for microentity, you just have to be an employee of a university. It doesn't mean that the university is the applicant, and in fact, the university is not allowed to be the applicant. It's a special fee reduction just for employees of U.S. Institutes of Higher Learning, regardless of their income. For most of you, if you do qualify for microentity status, it will be because of income, not under the higher education basis. For the income standard, the amount changes every year, but currently as of April 2018, the amount is $177,117. If you make that amount or less, then you might qualify as a microentity. And that income only include your income, not any spousal income, even if you file a joint return. The other requirement is that you can't have been named as an inventor on 4 or more prior patent applications. Not every application counts as those 4. For example, provisional applications don't count, and some other ones don't count too. So it's possible you may have filed more than 4 applications and still qualify, but you'll want to consult an attorney if that's the case. 2 other caveats for the income basis of being a microentity. One is that if there are joint inventors, each person has to qualify as a microentity. If one of the inventors doesn't qualify, then the entire application doesn't qualify, and you'll be a small entity. The other caveat is that even if your income is below the threshold, but you're obligated to assign your invention or you've licensed it to an entity that is not a microentity, then you can't be a microentity and would be a small or large entity depending on who you're licensing it to or signing it to. You don't need any form to say that you're a small entity. There's just a checkbox on what's called the application data sheet, which I'll get to in a future episode. But if you want to be considered a microentity, you'll need to fill out a 1-page form. You can find the form on the internet by a search for USPTO forms, PTO/SB15A, or PTO/SB 15B. The 15A form is for income basis, and the 15B form is for the higher education basis. It's really short. All you have to do is put in the application number or patent number, but you probably don't have those if you haven't filed your application yet. You put in the name of the first inventor and the title of the invention. Then there's some text that you have to read where it talks about how you qualify. Then print, sign, and date the form and include your telephone number. Sign at the bottom. If there's more than one of you, then each of you needs to sign a separate form. If you're filling out the form based on higher education basis, you either sign the part that says that you are an employee of a U.S. Institute of Higher Education, or whether you get that status because you're assigning it to or licensing it to an Institute of Higher Learning. One thing to think about when you're trying to figure out whether you're a small entity or a micro entity is whether it's worth saving a few hundred or a few $1,000s if you're wrong about your assessment. If it was an honest mistake, you can go back and make up the shortfall in fees. But if you did it fraudulently, it's considered inequitable conduct, and your patent could be unenforceable. So don't claim that you're a small entity or micro entity unless you really are. It's not worth the consequences, and even if you think you might qualify as a small or micro entity, it might not be worth the hassle in fixing it up because you'll probably have to pay attorney's fees to do all the paperwork. There are only a couple times where you have to inform the patent office of your status. The first is when you file, and the second is when you pay the issue fee, and the third is when you pay any maintenance fees. So if you were a micro entity when you filed, but soon afterwards you started making a lot of money and you don't qualify anymore, that's okay. You can continue paying the micro entity fees until your patent issues, and then you have to pay the issue fee. When you pay the issue fee, you have to pay it at that higher level, and the same goes for any maintenance fees. So, in sum, there's a good chance that you might qualify as a micro entity if you're a solo inventor making about $177,000 per year or less, and you get to usually pay 1/4 of the fees that a large entity would pay to the patent office. If you don't qualify under this standard, there's a good chance you may qualify as a small entity, where you can pay 1/2 of the patent office fees if you make more than $177,000 per year and you're a company with less than 500 employees. If you don't fit these categories for reduced fees, then you're a large entity. That's it for what you need to know on how you might be able to get reduced patent filing fees. If you want help with drafting your patent application, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.